We have major breaking news out of the United States Court of Appeals for the Third Circuit, which covers Delaware, Pennsylvania, and New Jersey. A 3-0 effectively anti-Second Amendment ruling. But it's complicated. It's complicated. We're going to explain why. This effectively allows the Delaware quote-unquote assault weapon ban on semi-automatic rifles and magazines to stand for the moment. But there's some twists and turns here that we got to talk about and get really geeky on. I think you're going to enjoy this, although we're not happy with the outcome so far. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Attacks on Israel Taught or Teaches Americans About the Right to Bear Arms. Check it out on Amazon.com. All right, folks, so a lot of you probably saw me this morning on Fox News talking about the dismissal of the case against Donald Trump and some related issues. So I'm going to be doing a lot of the Fox News stuff. So you'll be checking me out in a suit when you are tuned into the Fox News channel or Fox Business sometimes. Depends on the day. All right, with that said, folks, major breaking news out of Delaware. Now, I was very angry when I first read this opinion that's like 70 pages long that said, as a procedural matter, that the Second Amendment plaintiffs that brought this case in the case known as Delaware State Sportsmen's Association, among other plaintiffs, against the state of Delaware, that they had not done enough to establish a basis for receiving a preliminary injunction to enjoin the Delaware quote-unquote assault weapon ban law. But as I looked a little bit more carefully and as it sort of jogged my memory about this case and what the panel was, I kind of understand what happened. So let me just put it into context and let me talk about the three judges. And then I'm going to tell you what happened here, which may have been an extremely smart strategic play by a generally good originalist Second Amendment-oriented judge, Judge Bibas, out of the Third Circuit. So just to step back for a moment, this case arose from a law that was enacted, I believe, after Bruin that essentially banned semi-automatic rifles, quote-unquote assault weapons, the usual crap that goes on at these states, magazines that hold more than 10 rounds, that kind of stuff. The usual stuff Delaware did. Delaware, of course, is where Joe Biden comes from. For over a period of 6 or 7 months after that law went into effect, there were a series of lawsuits brought, some challenging the assault weapon ban component of it. Obviously, assault weapon is a political propaganda term. Some of it challenging the magazines. It gets consolidated on this appeal. I should note that the district court judge in the District of Delaware denied the motion for a preliminary injunction. Now, the argument made by the Second Amendment plaintiffs was, which is the correct one, and we'll get to that in a second, but it's a correct one that says that when you're applying a constitutional law and there is a violation or likely violation of that constitutional right by the government, that is all you need to establish to have a preliminary injunction put into place to protect you from government overreach and prosecution. In other words, you don't have to go out and show the typical 4 elements of a preliminary injunction, which is likelihood to win on the merits, plus irreparable harm to the plaintiff if the law is not enjoined, plus public interest, plus the balance of the equities, things like this. Now, most courts, including the Ninth Circuit Court of Appeals, by the way, say that once there is a violation or likely violation of a constitutional right, all 4 elements of a preliminary injunction standard are satisfied. Because once you're likely to win on the preliminary injunction based on the merits, meaning you're likely to win on the merits, then the government has no equitable argument in favor of enforcing the law because it's unconstitutional. There's no balance of the interest of public interest because there's no public interest in favor of enforcing unconstitutional laws. And there's irreparable harm because you are losing, for example, in this case, your Second Amendment rights, or your First Amendment rights, or whatever it is. That is the basic law across this country. What happened in this case is that this 3-0 decision out of the Third Circuit, which is precedential, laser focused on the procedural posture of this case. And what I mean by this is that the majority opinion, which is the court's opinion, did not address the Second Amendment merits, meaning they did not address the substantive Second Amendment law as to whether or not the Delaware law violated the Second Amendment. The three judges that wrote the majority, Judge Bibas wrote the majority opinion, laser focused on the fact that the preliminary injunction should not be allowed as a shortcut to decide the merits of the case, and said that the plaintiffs had not done enough to put on facts to show that the other elements of the preliminary injunction standard, of which is 4 elements, had been satisfied, and therefore it was correct in this 3-0 decision that the district court did not enjoin the Delaware law. And this entire decision by the court was on process, on procedure. And they sent it back to say, we're not saying at the end of the day what's going to happen on the merits of the Second Amendment claim, but on a procedural matter, we're not going to enjoin the law on a preliminary injunction basis. Now, at first glance, I'm going to be honest with you, when I looked at this, I immediately said to myself, well, Judge Stefanos Bibas, who's generally very good on Second Amendment and related issues, has just knocked himself off the short list to get nominated to the U.S. Supreme Court by future President Trump. That was my first reaction. I'm like, I'm going to go on and tell my 4 Box of Diner channel folks that this guy cannot be on the Supreme Court because he sided with the liberals. And then I looked a little bit more carefully at what happened here, and I looked at the other 2 judges on this 3-judge panel, and I realized that Judge Bibas may have done something extremely intelligent to actually protect the Second Amendment. That's right. That's right. Here's why I say that. I then looked at the whole gestalt of the opinion. And there's like 27 pages that rule against the Second Amendment plaintiffs on procedural grounds, but they don't talk about the substance of the Second Amendment. So they don't create any bad precedent involving the Second Amendment itself. They may create bad precedent for when a preliminary injunction can be procured in a constitutional case, but that's not necessarily specific to the Second Amendment. But then I realized there was a concurring opinion by the 89-year-old, hear what I just said? A concurring opinion by the 89-year-old Jane Roth, who is absolutely 1,000%, 1,000,000% awful, terrible, I need more adjectives, as to how bad she is when it comes to respecting Second Amendment rights. And she wrote a like a 25-page dissertation attacking the Second Amendment, saying that AR-15s and magazines are not even arms in the text of the right of the people to keep and bear arms. Her jurisprudence on the Second Amendment is pathetic and would get her an F failed out of the dumbest law school in America if she were a student. But she's not a student. She's an 89-year-old judge on the Third Circuit. So I realized then the other judge I should notice is Judge Montgomery Reeves, who is a Joe Biden pick. So then I realized what just happened. You had a 3-judge panel of a pretty strong Second Amendment originalist judge, very well respected, extremely intelligent, okay? Judge Bibas, very talented judge. That's why this was surprising to me at first. Then I saw the other 2 judges, Judge Roth and Judge Montgomery Reeves, a Biden pick, and Judge Roth, who's just terrible on the Second Amendment, absolutely terrible. And I realized what I think Judge Bibas must have done. He must have faced a choice. Now, I'm speculating here. I could be way wrong, but I'm usually pretty good about this, okay? Because I'm pretty good at thinking strategically. Being on Wall Street as a big-time lawyer for decades, you kind of get good at this. I think what happened is Judge Bibas realized he had 2 choices. He had the choice to let that terrible concurrence by Judge Roth, which was insanely bad for the Second Amendment, be written in a 2-to-1 with Judge Roth and the Biden judge. And then he could write a dissent explaining why it's absolutely wrong. But there would still be that 2-to-1 panel decision against the Second Amendment in favor of upholding an assault weapon ban of Delaware's. He could do that. Alternatively, Judge Bibas went the other path, which is to avoid a decision on the merits of the meaning of the Second Amendment. And to avoid that opinion by the Third Circuit that would be precedential, meaning it would have to be followed by other courts in the Third Circuit. To avoid that terrible anti-Second Amendment ruling on the merits, which he would have lost 2-1 because he had a Biden judge and Judge Jane Roth. So again, to avoid the 2-1 loss on the merits of the Second Amendment, on the meaning of the Second Amendment, I think Judge Bibas realized that the lesser evil alternative, meaning the less bad alternative, if the Second Amendment plaintiffs are going to lose this case right now on a preliminary injunction basis, I think he concluded it was better for them to lose on the procedural posture of the preliminary injunction standards rather than have a terrible anti-Second Amendment ruling issued by Judge Roth with Judge Montgomery Reeves signing on 2-1 against the Second Amendment. So therefore, I think that that's why Judge Bibas signed on to this decision against the Second Amendment plaintiffs in this case. Because what he also said, and this is quite telling, you know how I've said on this channel before, it's very important that now, given I don't think the lower courts are respecting the Second Amendment, and thus, in my opinion, as a general matter, we in the Second Amendment community want to lose cases fast. If you're going to lose a case, lose as fast as possible, get to the Supreme Court as fast as possible, and lose on the merits, because we know the Supreme Court has made clear they don't like dealing with stuff on an interlocutory basis. Lose, get a final judgment against you, take an appeal on the final judgment basis, and now it's not interlocutory, and go up to the Supreme Court, because that's where you're going to have to win it, because these lower court judges, in most instances, are doing crappy work on the Second Amendment. We've covered this. But what's quite interesting is that Judge Bibas outlined, and this is why I think he was thinking strategically, on page 26 of his opinion, he actually tells the Second Amendment plaintiffs' lawyers what they should be doing. He's essentially saying, when you listen to what he says, it's going to sound a whole lot like what Mark Smith says on the Four Boxes Diner about losing fast on the final judgment. Don't take interlocutory appeals. Don't take interlocutory anything. Just lose fast or win fast, get your final judgment, and move on to the higher courts. Here is what he writes, and he's basically signaling what I'm saying is correct. This is what he writes and why he's saying that preliminary injunctions are not the way to go. Do it differently. Here's what he writes. The challengers had other ways to get relief promptly. Our decision today leaves open several ways to vindicate constitutional rights promptly. First, a district court may move up the trial to consolidate it with the preliminary injunction hearing. Second, the court may convert a preliminary injunction motion into a summary judgment motion if they first give the parties enough notice. Third, rather than move for a preliminary injunction, rather than move for a preliminary injunction, the parties may agree to an accelerated trial. You see, Judge Bibas is basically saying to the Second Amendment movement, hey, guys, don't seek these preliminary injunctions anymore. It's not going to work. Do these other three things I've just outlined. Because these other three things I've just outlined will get you to a final judgment faster, and you'll get to the result you want faster than a preliminary injunction. Now, I should also note one other interesting thing is this is significant as to why I think he's upset with what the Second Amendment plaintiffs did here. He specifically said, and this is in the opinion, Judge Bibas writes the following, quote, here, meaning in this case, here, for instance, the trial would have happened. The trial would have happened in November 2023. November 2023. Final rulings on the merits would resolve issues definitively and let us review legal rulings de novo on fully developed records. He goes on to say that basically, in contrast, they took an appeal which slowed the case down. Again, stop seeking preliminary injunctions in these Second Amendment cases. Just litigate them on the merits, get a ruling. Now, I'm going to step back big picture because you turn to the Four Boxes Diner for the things you can't hear anywhere else because most other lawyers can't figure this out. Just the reality of it, okay? Not a big deal, not offensive. I'm just speaking the reality of it. Here's, I think, what's happening with the United States Supreme Court on the preliminary injunction stuff, on some of the standing issues. Now, some of the stuff I'm not super happy about right now, but let me tell you what's going on. Step back for a moment in time. Go back to the beginning. Remember, I'm making you the smartest person in the room. Here's how I'm going to do it. Go back to the start of the first Donald Trump administration. Do you remember how he had the travel bans and basically tried to stop immigration, slow immigration down, which is 100% the right policy? And then he was sued all the time. And what was going on at the start of the Trump administration is you'd have some nutty federal judge in Hawaii or New Mexico or California, I've lost track of all this, that one federal judge would enjoin nationwide, would enter a preliminary injunction nationwide and shut down the presidents. You had one nutty judge in Hawaii entering an injunction on a preliminary basis and essentially thwarted the entire executive branch, the entire federal government on a preliminary injunction basis. And a lot of Supreme Court justices like Neil Gorsuch have articulated the view that this is BS, that some district court judge can enter a preliminary injunction and shut down the president's foreign policy, for example. So I think what's happening here is that Judge Bibas, by writing this opinion on process, saying that the way the preliminary injunction standards have been applied in constitutional cases is not correct, he has effectively created a circuit split. Do you hear what I just said? A circuit split between the Third Circuit as to when a preliminary injunction should issue when a constitutional right is at issue, against, for example, the Ninth Circuit in the Baird versus Bonta case, where all you need to do in the Ninth Circuit is show a constitutional right is violated and an injunction will follow. So now the Third Circuit and the Ninth Circuit have a conflict, a circuit split. And you know what happens often when there's a circuit split? If you go to the U.S. Supreme Court to say you got to resolve the circuit split on this preliminary injunction process procedure question, meaning when does a preliminary injunction enter, where there's a circuit split of whether or not you just have to show a violation of a constitutional right or do you have to show those other factors, the U.S. Supreme Court may be in a position to take a case like this and resolve not the Second Amendment question, i.e. what does the Second Amendment mean, but decide as a procedural matter what standards have to be satisfied before a preliminary injunction can be entered against a government action where a constitutional right is at stake. Now, the reason why this may be extremely sophisticated on the part of Judge Bibas, who's extremely intelligent, an extremely good judge, and very good on the Second Amendment, which is why I was perplexed at the first, when I picked up this opinion today, I was perplexed. But I think I got what he was doing. By setting up this conflict, he may have been able to serve this issue on a silver platter to the United States Supreme Court. Why? Because I suspect that the Supreme Court, not being naive, they're not stupid, can see there is a high likelihood that in the next 6 months, you're going to have another administration run by President Donald Trump. And we already know from the newspapers that the left in America is already talking about ginning up lawsuits to shut down all of Trump's policies the same way they did after he was elected in 2016. And the way the anti-Trumpers were able to use lawfare and lawsuits to shut down Trump's policies were by abusing these preliminary injunction standards. So here you have Judge Bibas is basically trying to heighten the standards before someone can get an injunction on constitutional arguments. He's also created a circuit split with the Ninth Circuit, which means that the Supreme Court has the option possibly, to take a case like this to say there's a circuit split about the standards for a preliminary injunction. And because we know, looking down the chessboard 6 months, that the anti-Trumpers are going to try to get injunctions of every Trump policy in every court in America, and we don't want to allow that to occur again, where you have a district court judge in Hawaii shutting down the Trump administration number 2, I could see the Supreme Court taking this opportunity, this invitation from Judge Bibas, if you will, to deal with the process of when a district court can enjoin a law on constitutional grounds and use this as a way to prevent the lower courts from abusing their injunctive equitable relief powers, if you will, against the next Trump administration. Now, there's a lot of deep thinking that I just articulated, a lot to think about here. But the bottom line is, even though at first I was very upset that Judge Stephanos Bibas wrote this opinion against the Second Amendment plaintiffs, when I look more carefully at the alternative, which was that the Judge Roth concurrence would have been the majority 2-1, and it would have been absolutely awful for the Second Amendment. And then I realized that Judge Bibas may be setting up the U.S. Supreme Court to let them fix the problem they experienced in 2016 with abusing district courts in the left-wing jurisdictions to shut down the Trump administration's policies, I realized there may be a method to the madness of Judge Bibas basically ruling against the Second Amendment plaintiffs the way he did it. Because remember, I'll leave you with this. It's not just about winning cases at the high levels of court, at the highest levels of law. It's not just about winning cases. Yes, you want to win the case. It's equally important at the highest levels of legal practice and law, the way you win the case, right? Because it's the methodology, the approach, the interpretive approaches that judges apply that other judges will follow. So again, Judge Bibas may have realized that the Second Amendment plaintiffs had no chance to win this case because he was in the minority 2-1. So the question became, how does he best lose the case for the Second Amendment to do the least damage to the fundamental right to keep and bear arms? And he may have made the strategic choice that they should 3-0 rule against the Second Amendment plaintiffs on procedural grounds to avoid a catastrophic loss on the meaning of the Second Amendment, written by the 89-year-old Judge Jane Roth. Okay, hope this video was not too geeky for you. Hope you learned something. Make sure you follow me on X at 4Boxes Diner. A lot of information there in addition to what I'm able to cover on videos. Don't forget to follow me on this channel, and I appreciate the support. And we will talk to you again soon here at the 4Boxes Diner.
Orders up. Table 2A.